This was a topic on the Big Five earlier in the week, and we actually ended up opening up our phone lines for a short while on this one, and I was amazed just how quickly we got people chiming in on the subject. It all had to do with social media, and if social media companies should be liable for their products in the same way we found tobacco companies liable decades ago for what their products did to people and their health. Now, opening statements were made on Monday in a landmark trial that claims Meta and YouTube created digital casinos. The trial centers on a young woman who says Instagram and YouTube were deliberately engineered to hook her as a child, causing serious harm, and that tech companies knew the risks and kept going anyway. It's the first of several high-stakes cases testing a new legal theory that social media can be as addictive and as legally liable as cigarettes or casinos. And just last week, news from Europe. European regulators found that TikTok's infinite scroll and personalized algorithm led to compulsive behavior, especially among kids, and they released a preliminary decision that deemed the app, quote, likely illegal. So the pressure's on here. Let's go to Matthew Bergman now. He's founding attorney of the Social Media Victims Law Center. Matthew, welcome back to the program.
Thank you. Thank you for having me.
How do you view this lawsuit happening in California that started off this week? How influential, how important is it?
Oh, this is incredibly influential. This is really the culmination of a 3.5-year effort by families to hold social media companies accountable. The fact that we are simply able to go to court and present our case to a fair and impartial jury is in and of itself a huge victory and a major step in holding social media companies accountable.
And let me ask you if all social media companies have been treating this lawsuit the same way. And I note here that in this case, it's Meta and Google, YouTube, in the courtroom this time around. Why don't I see other companies here? There's far more social media companies than just those two.
Well, there were 4 companies. There was also TikTok and Snapchat that were in the case, and they resolved. And we base the case on each case is different, and not every kid is harmed by every single social media platform. So each case requires a careful and individual workup to determine which companies are responsible for the harms that the child sustained.
So TikTok. So you say TikTok, Snapchat, they settled before this went to trial.
That is correct.
Okay, gotcha. So what's at stake here, Matthew, in your opinion?
Well, what's at stake is this is the first time that a social media company ever has been subject to public review by a jury of its peers. Documents that they have hidden, internal documents that contrast to the public persona that these companies proclaim, will be presented for the first time. Literally today, Adam Mosseri, the CEO of Instagram, is going to have to stand in front of a jury and answer questions under oath about why his profits were more important than our kids' safety. And for the first time, it's not going to be like a Senate hearing where after 5 minutes the baton is passed to somebody else. He's going to have to actually answer the questions truthfully under oath. And Mark Zuckerberg as well is going to have to come and account for his company. This is it is unfathomable to me, or it was unfathomable to me 3.5 years ago that we would get to this point. Look, every trial is difficult. There's a reason why it's called trial, and we have the burden of proof, which we gladly take. But simply having the opportunity to prove our case is a huge victory in and of itself, no matter what the jury ultimately decides.
What's the evidence that will be presented? To make your case here. What's the evidence on that? Instagram, the YouTube, that they knew exactly what they were doing when it comes to hooking children.
Well, the strongest evidence is their own internal documents. Their own internal documents indicating that they intentionally designed platforms to addict children, and the word addiction is their words, not mine. That they knew that the best way they could make money would be to maximize the amount of time that adolescents were online, and they had very experienced and knowledgeable psychologists, neurologists, computer scientists who designed platforms to appeal to and take advantage of the vulnerabilities of young people. A young brain is not fully developed, and their dopamine response is much more acute. In addition, young people are so needy of social acclaim that anything like buttons or streaks or push notifications that gives kids the sense that they are part of a greater community is something that's a very powerful force to be exploited. And we had testimony yesterday from one of the foremost experts in addiction, who was able to explain to the jury exactly what the product features are in Meta, in Instagram and YouTube, how they are addictive, and how they take advantage of a young person's diminished neurologic development and social maladroitness to maximize engagement. Remember, when you are on social media, you are not the customer, you are the product. They are selling your time. The more time that a kid spends online, the more advertising the companies can show her or him, and the more money they make. So their platforms are singularly designed to maximize the amount of time that kids spend online, as opposed to the quality of their online experience. They do that by showing kids not what they want to see, but what they can't look away from. And we're here in court to finally hold these companies accountable for the horrific consequences of their deliberate design decisions.
Matthew, one of the things that came up when I discussed this lawsuit with our listeners earlier in the week, I did have a vocal group of listeners that said, hold on a second, this is the parents' fault. If my child got addicted to drugs, well, there'd be some blame on the parents. So if my child gets addicted to social media, it's on the parents. What do you say to that? And I wonder if that may be the argument that's going to come from YouTube and Meta and Google and the like. What do you say to that reasoning?
Well, first I say that we're all for parental responsibility. We're all for parental accountability. These platforms are explicitly designed to evade parental responsibility. Young people are encouraged to open multiple accounts to evade their parents' prying eyes. Instagram calls that a value add. And Meta's own internal research shows that parental involvement does not impact addiction. And so parents are doing their level best to monitor what their kids are doing online, but they're paddling upstream because these platforms are deliberately designed to make it harder for parents to do their job. And the fact is that most kids are more tech savvy than their parents, and it shouldn't come as a newsflash that most teenagers don't tell their parents everything they are doing. So we don't think that there's a binary choice between a parental responsibility and holding these companies accountable. We believe that these companies, and we believe the evidence will show that these companies have deliberately tried to subvert and short-circuit parental authority.
Matthew, the world's going to be watching when these CEOs testify at this trial. Thank you so much for giving us the lowdown on your case. Really appreciate it.
Well, thank you very much, and thank you for your interest in this topic.
Matthew Bergman there, founding attorney of the Social Media Victims Law Center.
I'm Dylan Playfair.
And I'm Tyler Smith.
We're putting loneliness in the penalty box by talking to some of our favorite athletes about the importance of friendship.
This is Bromance.
Bromance is brought to you by Charm Diamond Centers, proudly Canadian-owned and operated. Charm has been part of your love stories and bromances for over 50 years. And you can find Bromance on the iHeartRadio network or wherever you get your podcasts.